Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. You're welcome to today's show at Heritage TV, hanging out with BWF solicitors. Today is going to be another wonderful discussion. It's different, very, very different. Our guest today is lawyer Eunice Achampo, partner at BWF Solicitors, who will be taking up today's topic, which is the EUSS Leave to Remain. How long can one stay outside the UK for? Some of the few questions that was asked on social media when I first advertised today's show was, such as will periods of 6 months or more spent outside the UK in a 12-month period, and many more questions also regarding COVID-19, being absent from the UK for quite a long period of time due to the COVID-19 restrictions. All these questions and more will be answered by our guest, lawyer Eunice Achampo, who is a partner at BWF Solicitors. May I also remind you that this program is streamed live. You can contact us through our social media handles with all your questions and comments. If you prefer to call us directly, you can call us on 0744 8619711. The number again is 0744 8619711. This program was proudly sponsored by BWF Solicitors, Victon Estates Limited, and Eagle Heights International School. Let me quickly welcome our last partner at BWF Solicitors. Hello, Lawyer Eunice.
Hi, Vicky. How are you?
Thank you. How have you been? How was your week like? I know you solicitors are always busy, but I still have to ask.
Of course. My week was good by God's grace, and of course, as you say, we tend to be busy, but at least things are not as busy, but we are taking up the pace, and we are actually obviously trying to work through all the backlogs and things that we have. So, yes, by God's grace, we are doing well.
Okay. All right. Lawyer Eunice, take us through any updates before, going with
Okay.
today's topic. Yeah.
Okay, so very briefly in regards to our updates, I know that last week was when the government put out their statement of changes. So this is the Home Secretary and her department. And the statement of changes is in relation to any amendments or any rules that have changed in regards to our immigration rules. And there have been quite a number of changes, a number of introductions, and amendments to our immigration rules as it stands. And these rules will come into force from the 1st of October or the 6th of October this year. And then later on in October, around the 11th, some more will be in force. But of course, there are 183 pages in this statement of changes. So, of course, I can't lay out everything that has changed within the immigration rules, but I'm going to pick on quite a few which will be relevant to our viewers and listeners. So, of course, we all know about the fact that when the coronavirus hit last year, there were some concessions that the government made in regards to those that stayed out of the UK for a period of time and couldn't return, and how they were affected by not being able to make any leave to remain application or extend their leave to remain applications whilst they were away. And so, of course, you have these policies that they brought sometime last year being implemented into our immigration rules. So no longer is it just some policy that they have announced. It is part of our immigration rules, which is secondary legislation. So when we say secondary legislation, it means that a government department can make their own laws, which obviously have to be abided by. And so when you look at the immigration rules specifically, you look at Appendix FM in regards to coronavirus concessions, where people had to stay out of the UK and couldn't return until sometime in July last year. So they've obviously said that if you were not able to return and your leave expired whilst you were out of the UK, then of course you would be able to make an extension, and any period between January 2020 to August of 2020, if your leave had expired and you were applying for an extension, that period of time will not be counted against you. So you wouldn't see that as a break in your leave to remain. So that has been added on to paragraph 39E, which specifically states that if you are unable to put in an application before your leave expires, you have within 14 days to put in your application. So, of course, because of coronavirus, that period of time would not have been enough for those who were out of the country for a longer period of time. And then, of course, there were other concessions in other routes or categories. So you have categories such as the student visa route and the skilled worker route. and even the innovator and the global talent routes, who all had some concessions in regards to coronavirus. And so for some, it might have been the fact that they met when they were not able to meet their financial requirement due to the fact that they could not work or couldn't start up their business during the coronavirus period, or the fact that, for instance, because they needed a lot of healthcare workers during the time, even though decisions had not been made on their leave to remain, they could start work. So if they previously had leave to remain and they had not received a decision for their extension, they could continue working because, of course, there was that shortage in our health sector. You even had people who were applying for extensions as students who could start their course even without a decision. So all of those concessions have now been put under our immigration rules. And then, of course, when you look at our EU settlement scheme, as we'll be discussing today, you have, of course, those that are family members of EU nationals. So we all know that usually when you come into the UK and you come with a visitor's visa, you are not able to apply to switch to any other route. And of course, because of coronavirus, they've said that in regards to those who are family members of EU nationals, if they have come into the UK as visitors, they can still apply onto the EU settlement scheme. And so, if for one reason or the other, let's say your child came to visit you and they are applying under the EU settlement scheme, they should be able to make that application. And of course, when it comes to the main topic for today, we'll be looking at how, of course, coronavirus and the restrictions that played a part in it have allowed people who stayed outside of the UK to also make their applications under the EU settlement scheme. And I know that a lot of the time, many of us who have degrees outside of the UK may have heard about NARIC, so UK NARIC. And when you're making any leave to remain application or application for indefinite leave or naturalization, you'll be asked to provide evidence of your English language in the UK. And of course, most of the time, we all know that UK NARIC is where to go to have that certificate assessed in order to find out if you meet the required qualification framework level, either at a level A1 or A2 or B1 or B2 or C1. You have to meet either level depending on the route you are applying on. And as we used to know UK NARIC, now they have introduced a new establishment and its name is ECTIS. So no longer would they be referred to as UK NARIC, now it's called ECTIS, and ECTIS will be the main body assessing people's English language framework. So ECTIS is ECCTIS, and they will be the new body doing that assessment in terms of those who have degrees that they received outside of the UK. And of course, there are so many other amendments. So you have, the Afghan citizens or those that are applying to seek asylum here in the UK, and those who, of course, would be applying as dependents of Afghan citizens here in the UK. And of course, if you are in the troubled country right now and you are looking to make an application, of course, if you have a family member who is already here, under Part 7 of our immigration rules, it is looking at how those family members can even join just for that route exactly, to be able to join their family members through a leave to remain application, but more so the introduction of you applying for indefinite leave to enter really helps, because there is no way that you would be able to say that you'll be returning to such a country which is in so much turmoil at the moment. And so it helps that at least these family members can also apply under this route. So there are quite a few amendments and changes and introductions. And as time goes on, if there's something that catches my eye that is relevant to us, I will let it out and then make our viewers and listeners very much aware.
Okay, all right, brilliant. Laura Eunice, so regarding today's topic, what is a continuous qualifying period under the Appendix EU?
Okay, so when you look specifically at our Appendix EU, a lot of the time, I think that those who are still family members of EU nationals or EU nationals themselves, or even those that have retained their right, and those that would say are primary carers of EU national children or British
Yeah.
children, are those that would usually be applying for leave or indefinite leave to remain under the EU settlement scheme. And then you also have British nationals who have gone to live outside of the UK with their family members over a period of time and would be returning to the UK. And of course, they have an extended period of time to put in their applications under the EU settlement scheme. But of course, when we look at the fact that we had this deadline of the 30th of June to 2021, a lot of people were worried about that deadline. I was asked by somebody, oh, does it include the spouse of an EU national? And I said, yes, it includes anybody who is a family member of an EU national. So, regardless of whether you are the child or you are the parent or the spouse, the EU settlement scheme was introduced as a way to protect all EU nationals and their family members and all those that the EU treaty covered, so that at least they would not be found wanting once the UK left the EU, which we all know happened in January 2020. So, of course, the EU settlement scheme is for every person who was previously covered under our EU regulations 2016. And so, of course, yes, we know the 30th of June deadline has passed, but they have also said that if you have reasonable grounds for which you were not able to make the application, you can still put in the application. So there isn't now a new deadline that you have to have put in the application by. And so all these categories of people who need to apply to the scheme will be either granted limited leave to remain, which is for a period of 5 years, and then some of us who obviously have continuous residence here in the UK for 5 years would be applying for indefinite leave to remain in the UK. And so, of course, when we look at that continuous qualifying period, it is to say that you want to be able to show that as much as possible you have completed that continuous period of less than 5 years. So less than 5 years could be a year, 6 months, 1 month, 2 years, 4 years. And then, of course, that would warrant an application for limited leave to remain under Appendix EU. And if you are somebody who is saying that has lived in the UK for more than 5 years, or you have lived in the UK for a continuous period of 5 years or more, then of course you will be looking to make an application for settled status, which is indefinite leave to remain. And so the reason why it is continuous is because there are certain breaks that will be counted against you if you were not able to meet that periods of time, such as staying out of the UK for a period of more than 6 months or a year or more, or the fact that maybe you had your leave revoked or cancelled, or that you were imprisoned for an offence or sentenced to either a period of 3 months, 6 months, or even the fact that they may have deported you. And so all these things can break a person's residence here in the UK. So, of course, we want to look at how we can meet that continuous qualifying period assessment so that when it comes time for you to make that application for settled status or for indefinite leave to remain under Appendix EU, you have no issues at all. Of course, somebody who already has permanent residence card is able to show that they already have 5 years continuous residence, and that is why they were granted that permanent residence card. So if somebody like that was making an application, they would be granted indefinite leave to remain straight away. So of course, when it comes to those applications, we want to advise people when certain absences are okay and when they are not okay, and how best to make sure that you are able to meet that continuous qualifying period.
Well, talking about the period of time and the number of months that you can stay outside the UK, in comparison to those who have settled status, they
Mhm.
can leave the UK longer than those who haven't got had their
Yeah.
settled status. If that's the case, how long does one who has settled stay outside the UK?
So the good thing about our Appendix EU is the fact that it's quite flexible. So those previously under our regulation 2016. So if you have a permanent residence card and you haven't done any application under the EU settlement scheme, if you were to go outside of the UK and you stayed outside of the UK for a period of 2 years, you would literally be saying to yourself, I don't want to come back to the UK anymore, because that in itself cancels your indefinite leave, or shall I say, it cancels your permanent residence here in the UK. But if you have made an EU settlement scheme application and you have been granted settled status, and of course, you will say that you are somebody who has stayed outside of the UK for a period of at least 5 years, at least, of course, you can return within that 5 year period. But if it's more than that 5 year period, then of course you are saying that you have broken that period of residence and you have to make an application as a returning resident coming back to the UK. So it's important that you don't stay out for more than 5 years.
Oh, okay, great. Yeah, yeah. Ladies and gentlemen, just joined us today. EU settlement scheme leave to remain. How long can one stay outside the UK for? And with me is lawyer Eunice Achampong, partner at BWF Solicitor. If you want to contribute to the program or send in your comments, please do so on all our social media handles: Facebook, YouTube, Periscope, Twitter, all our social media handles. You can watch us live at BWF Solicitors Facebook page. This program is sponsored by BWF Solicitors, Victor Estate Limited, and Eagle Heights International School. If you prefer to call me live on this program, the number is 0744 8619 711. The number again is 0744 8619 711. I'll be expecting your calls and your contributions. Lawyer Eunice.
Hi.
Yes. Yes. I've got a question here from Nelly. I went to Germany in January last year while I was pregnant. I was having a difficult pregnancy. and needed the help of my mother who lives in Germany. Things did not go as planned, and I had the baby prematurely at 26 weeks old. My mother helped nurse and care for the baby. I didn't return to the UK until January 2021. I was told about the EU settlement scheme, so I applied in April 2021. As I am a German national, I didn't go for biometrics. I have not heard from them since. What do I do? What are you know?
Okay, so we have somebody who obviously is saying that they left the UK for quite some time. So she says from January 2020, and she only returned in January 2021.
Girl.
So this is looking at a period of at least 12 months or more. And of course, if you are um, an EU citizen and you are saying to yourself, well, I've now made this application for this EU settlement scheme, and now I don't know, they haven't said anything, they haven't responded to me, what do I do? Of course, like I said, most of the time when you look at those that make the applications, it has to do with those that are EU nationals and their family members. And for
Mm,
her, because she even made the application before the 30th of June deadline, at least she is within that grace period that they gave. And so, of course, she would have done the application either by app, because for most EU
mm,
nationals, the application could have been done on their phone. So, as long as you downloaded the UK IV app, you would have been able to um, download the app and then do the application and everything on there. And so, usually, what happens is that once you've done what the necessary checks and you've completed the application online, you can then go ahead and then wait for a certificate of application. And then once the
yeah,
certificate of application has been granted, you wait for them to make their decision. Of course, it's supposed to be very straightforward, but because I think that they've had to deal with a lot of their backlog, they haven't been able to really make decisions as quickly as they should. And so, in this
okay,
case, I would say that because it's almost 6 months, she said she made it in April. So I'm guessing that, of course, it's almost 6 months since the application was done. I can bet you that if they haven't made a decision now and they haven't brought any email correspondence, then this is where you need to prompt them. So she can either put in a complaint to say that she hasn't heard anything from them since she made the application in April of this year. And of course, if she did the application through a lawyer, they could put in a pre-action protocol just to let them know that they have overdone their 6 month period, and therefore they need to obviously let us know what the decision is. Of course, I'm not sure whether she uploaded any documents, and if she
mm,
didn't, then maybe the caseworker working on the case would need to request for further documents. And that's what usually happens once a PAP has gone through. So if they don't have enough evidence to make their decision, they would request for further documentation within a 14-day period to be able to make their decision. And in this case, because she said she was out of the country and she was
yeah,
obviously a nursing mother who had difficulty in her pregnancy and needed the help of her mother, this will be seen as a reasonable excuse under Annex 1 of the Appendix EU, where she can say that because of the fact that she had complications and the fact that the baby came early, all of this led to her staying out of the UK for a period of 12 months. And obviously, she will need to provide that evidence if she was in Germany and she had gone to hospital or any medical antenatal medical centers. She would need to provide all of that evidence to them so that, of course, that period which she was out of the UK will not be counted against her. So she hasn't really said how long she's lived in the UK for, but providing that evidence will help in them making the assessment whether to grant her pre-settled status or settled status.
Okay. All right. Great. I've got another question from Gregory. It says, dear lawyer, thank you for this program. It's very, very educative. I'm getting a lot of information from this. He says I'm an Italian national, and I would like to find out if I can go back to Italy for about 6 months. I had some work there I was doing, and will come for some time and go again after 3 months in the UK. Will that affect me when I'm going for my indefinite?
Okay, so with Greg, of course, if you are saying that you are somebody who lives here in the UK and you are resident here, I'm wondering why you would need to go back to Italy to go and work. Um, Sometimes it baffles me because I'm thinking to myself, most of the time people say that it's because of the work that they come here. So then I'm thinking maybe it's some self-employment that they used to have, and so they need to go and finish up on business as it were. Well, when we look at our immigration rules, when you look specifically at Annex 1, which talks about our continuous qualifying period, and the fact that, of course, if you were out of the UK for a period of 6 months or less, that on its own will not really affect your resident status. But if you were to be out for a period exceeding 6 months,
Yeah.
then of course they will be looking into whether there has been a break in your continuous qualifying period. And so he's saying that he will be back within 6 months. That's
Yeah.
perfect. But then he mentions that he's going to come back for a period of 3 months and then go again,
Yeah.
of course, to Italy. That, of course, may break his period of residence when he goes the second time round. Because in a
All right.
12-month period, they are looking that you don't exceed the 6 months. And so if you say that you are going for a period of about 6 months, that's fair enough. But where you are going within a 12-month period and your leave or your absence outside of the UK exceeds that 6 months, then it means that, of course, there might be a break. And him saying that he has some work there is not a reasonable excuse. Because unfortunately, if this country is your country of residence, then of course you should be working here in the UK, and everything should be done as you would if you were residing in any other country. And so, unfortunately, going to Italy to work or to go and get some things that you've imported, and all of that is not a reasonable excuse why the absence was made. And so, of course, you want to be looking at how best to make sure that when you're out of the UK, the reasons are quite reasonable. It would have been different if he said, okay, I have my brother there. My brother has fallen ill. I need to go and take care of my brother. And of course, whilst you are there, maybe one thing led to another. There were complications, and that's why you have to stay longer than the 6 months. So maybe he came for 6 months and then he had to go again because of the fact that his brother was ill. That would have been different, because if it was a serious illness, you will need to provide evidence, and then they can look into that and then, of course, excuse that absence. So if it's just for work reasons, then unfortunately, he will be putting himself into a pickle. So it's better that he is able to show that it is not about work, but maybe, for instance, there was some serious illness in regards to a family member he had to go and look after. And of course, you should be able to provide evidence in relation to that.
Okay. Okay. Right. I hope he listens to your advice because it's so painful when you have stayed in this country legally. Then when it gets to when you have to go in for your indefinite, meaning there would not be any restrictions on you in the
Mm,
country, and because you've been staying, it looks
yeah.
like the period of your stay in the country is less than you staying in Italy. It's going to affect your indefinite leave to remain. It would be so sad. So I hope
Mm.
that takes your advice seriously and look into it. Yeah, lawyer Eunice, this person wants to stay anonymous. He says, I went to Spain last year, early March, when the pandemic broke and when the travel restrictions were put in place. I was not able to return to the UK. I only came back to the UK in September 2020. I didn't know I had to apply under the EU settlement scheme as a Spanish. Can I still apply to get my settled status?
Wow. Okay. So in this case, you have somebody who obviously was out of the country and was no fault of hers. And so, of course, she came back when she could, or he came back when he could. And they didn't know that there was an EU settlement scheme going on. Um, as I mentioned earlier during the program, if you are saying that for one reason or the other, you've had to stay outside of the UK, of course, you will need to also show that it was for a reasonable reason, and that's why you had to stay outside of the UK. And in this case, it's due to the fact that there were COVID restrictions in place. And I think that of course nobody is at fault when it comes to the pandemic, because the pandemic has brought about so many other things that we could not control. And when things are out of your control, you nobody or no person is at fault. And
Yeah.
that's why the government have had to put certain concessions in place just to protect people as it is. And
Mm.
so, in her or his scenario, if this person is saying that they had no idea about this EU settlement scheme, and the fact that they've also stayed maybe longer than 6 months outside of the UK, and how this will affect them, um, hopefully they should have evidence of the on their passports or their travel itinerary, which shows that, of course, they left the UK at this time due to the travel restrictions in Spain. They could not come back until the set time in September, and a lot of this will be on the government websites, whether in Spain or even in the UK, because there were a lot of countries that had restrictions, and they could not allow for other nationals to enter or for their nationals to leave the said country. And so, if it's the case that the travel restrictions were held until sometime in September, and that is when they could arrive, then of course they can provide such evidence. And when it comes to putting in the application, they will be sure to put in the application online. They will have to have a reason why they couldn't make the application before the 30th of June, 2021. And so, as we all know, if you were not aware of the fact that there was an EU settlement scheme, and I believe that it's now that most employers are getting themselves aware. I used to think that all employers knew about this if they have EU national workers, but I was wrong. Somebody came to me and they were like, well, my employer didn't tell me anything. And so I was like, oh, okay. And even when they were trying to find out from their employer did not have a clue as to what they were talking about. So,
Mm.
of course, this is something that quite a number of agencies and institutions are still getting their head around, and the information, I think, needs time to really sift through the masses. Because if an employer is not even aware of what EU settlement scheme is, let alone the employee. So, of course, if they have now decided to put in the EU settlement scheme application, they can do so. Make sure that they obviously take the right option, because there are quite a few options in regards to reasons why people did not make the application before the 30th of June deadline. They can put in the one which is most suitable to them, and then of course go ahead and submit the application. And once you're coming to the end of the application, sorry, it will always ask for evidence to be uploaded, whether you are applying for pre-settled status, which means that you are applying for leave to remain, and you are providing evidence to show that at least you have lived in the UK for less than a period of a year, but you were in the UK before 31st of December 2020. And it's that harsh, because anytime anybody makes an application after this 30th of June deadline, even after the 1st of January 2021, they would always come back with an email asking, please provide evidence that you lived in the UK before 31st December 2020. So as long as you have
Okay.
evidence from previous years, so 2018, 2015, 2016, any period before 31st December 2020, then you know that you are settled. But if the evidence is not forthcoming that you were living here before the 31st of December 2020, then it makes it difficult, because we all know that from the 1st of January 2021, any EU national that entered the UK could not come under the EU treaty rights for free movement. So no EU national who came to the UK after the 1st of January would be able to reside here if they were not residing here already. And so it's
Okay.
important that she knows that if she has some reasonable excuse and she can provide evidence that she was here before 31st December 2020, she should upload that as well as the tickets, the itineraries, and things that show when she left and when she obviously came back. And of course, once that has been included, or that has been added on to the scanned document, they will look at that and then forgive any period of absence. And of course, you have a lot of EU nationals who would have used their time wisely. So even if they were doing some sort of short course whilst they were in Spain or whatever, that could also be seen as a reasonable excuse for not being in the country. And I know quite a few students who were not able to return because, of
Okay.
course, there was a pandemic. And so, if you had something in relation to any sort of study, that also could be seen as some reasonable excuse why you were not able to return to the UK.
Wow. No, Eunice, in the absence of any other questions, I just wanted to ask this. I just
Mm.
need your honest opinion. Has it become easier this time round for people to regularize their stay in the UK? Because I'm having this notion that it looks like there are so many avenues as compared to a couple of years ago. What is your take
I
on that?
think, okay, so it's quite a broad question. If I'm looking at it from the perspective of a lawyer who is now looking at our immigration rules, of course, the introduction of our points-based system. So it's not as if we didn't have that before under tier 2, tier 4, tier 5. But of course, we now have an introduction where those that are even coming into the UK as skilled workers have different options available to them. And especially when it comes to the healthcare sector, that in itself has created a boom because as soon as Brexit was announced, I think that a lot of EU nationals that were working within that sector began to leave, and so that didn't help the care sector. So, of course, you realize that there was a reduction in the workforce, and they needed people to fill up those vacancies or those spaces very quickly. And a lot of the time, you are looking to people close to you or in the country. And so, even with the skilled worker visa, you should be able to show that you have made every effort to advertise to people in the country before going out there to get somebody to help in the workforce. And so, even now, when you look at our skilled worker routes, those in the EU are looked at more favorably because the fees that they will pay are half of the fees that somebody outside of the EU would pay for any of the skilled worker or student categories. And so, of course, that in itself has created a variety of areas in which a person can apply. And I will say that, of course, coronavirus and the fact that the restrictions played a big role has helped people put in applications that they wouldn't necessarily be able to put in. So, like I was saying at the beginning, there were people who would have put in visit visas application. They couldn't return to their country of origin. They had to stay longer than the 6 months. And the government was saying, well, if you have family members here, either a spouse or a child, you can put in an application. Or if you believe that you can switch on to the student or the skilled worker route, you can do so. And it was not heard of. And I think that it created an avenue for so many people who were in the country who had visit visas, and this was like their prayer answered because they could see their a way out, and they could see that they could make those switches without having to return to their country. And so that was very helpful. And I know that currently those on visit visas can still apply for assurance, or they can still apply for an extension up to the 30th of September this year, because you have countries that are still on the red list and amber list, and they are looking to revamp their listing, that's as they say. And so if that creates further restrictions, they might look into extending that period of time in which visitors who are here in the UK can obviously have their visit or their leave extended for. And we all know that you can't exceed a 6-month period once you come for a visit here in the UK. And the fact that they can extend it for you is great news. Of course, you should have reasonable reasons why you would want that extension. You can't just ask for an extension. You should have a very good reason, and of course, it will be extended up to the period of time for which you believe you are requesting. So, of course, now that we have these concessions in place, that has also helped a whole lot of people as well. In terms of those that were already in the UK before the pandemic, it may not have helped them so much because they were still in the UK before the pandemic came. But for those who came during the time of the pandemic or whilst the pandemic was ongoing, of course, they've had to benefit from all of this. And let's see how things turn out. I think that, of course, that would help a lot of our people who are looking to see how they can also come into the UK. But for those who were already here before the pandemic hit, I guess you can say that they wouldn't think it has been favorable to them. But we thank God that at least some people have been able to also benefit from it.
All right. So, Laura Eunice, I think we've exhausted all our questions. The fact that we didn't get a lot of questions on this topic, I was anticipating to get so many questions, but for some reason, I think our viewers are satisfied with the discussion today. Your explanation, points raised, advice given, and how you answered all those questions that came in. So I believe that everybody is happy with whatever was discussed today. So, like Eunice, if you could please quickly summarize and give your details if someone wants to get in touch with you.
Okay. So, we've been discussing how long a person can stay outside of the UK if they are applying to the EU settlement scheme. And of course, we've looked at the fact that if you are making an application for settled status or pre settled status, which is limited leave to remain, and settled status, which is indefinite leave to remain, you should be able to show that you have lived in the UK for a continuous period of less than 5 years or for a continuous period of 5 years or more. And so, of course, if you have evidence that you've resided in the UK for a continuous period of 5 years or less than 5 years, you would be able to put in that application. But then, of course, for those who may not be able to show that continuous period because they have been absent from the UK, they should be able to provide evidence for the reasons why they were absent. And if, of course, they were absent for a period of 6 months or less, that absence will not be counted against them. But where the absence has been for a period of more than 6 months, then it means that, of course, they should be able to give reasonable reasons why that absence exceeded that period. And not every reason is reasonable. So, you going out there to work or to go and get some products or whatever it is may not be a reasonable excuse why you left the UK. But at least if you are able to show that you had some serious illness or you were taking care of somebody who was seriously ill or you had to go because you were having complications with your pregnancy.
La Eunice, are you there? All right, ladies and gentlemen, we'll try and get Lawyer Eunice back. Whilst I'm waiting for Lawyer Eunice to join me quickly, I
Of
would like
course.
to also say that, oh, wonderful. All right, please go on.
So, where of course you are saying that there has been a break because maybe your leave got cancelled, or maybe you were sentenced because you committed a criminal offense, and maybe for one reason or the other you had a deportation order against you. Those can cause a break in your continuous residence, and so things like that, of course, will bring about a break, and that would mean that you would need to start the 5 years all over again. But of course, if you are able to provide reasonable reasons, which I have explained beforehand, then of course that would not be used against you. So, yes, as we always say, we do not just deal with immigration law. We, of course, deal with other areas of law, including nationality, including things like child arrangement orders, non molestation orders, occupation orders, divorce, and other social issues as well. And so, if you do need legal assistance, do not hesitate to contact us at BWF Solicitors. Our offices are situated in London, so the fourth floor of Anna House, 214 to 218 Tottenham High Road, and the area is London, as I said, and the postcode is N15 4NP. So N15 4NP. Our offices are open from Monday to Friday, and the main office number is 0208 493 7340. So 0208 493 7340. And of course, my number or my out of office number is 075 35 81 3910. So 075 35 81 3910.
Great. Lawyer Eunice, thank you so much for today. I just don't know what to say, but we really appreciate your time coming on every Saturday with us to educate us. We very much appreciate it, not taking it for granted. I thank all our viewers who stayed with us throughout the program. Without you, it's not going to be as successful as it's been. Also saying a big thank you to all those who sent in their questions as well. As Lawyer Eunice has given her details, if you have any further queries or concerns or questions, please do not hesitate and get Lawyer Eunice on the details that she's given you. Want to take this opportunity to say a big thank you to our sponsors, BWF Solicitors and Victon Estates Limited, not forgetting Eagle Heights International School. Until we meet again next week, same time with another interesting topic, take care of yourself and enjoy the rest of your week. Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Victon Estates provides professional and reliable service to landlords, investors and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.